Good afternoon. And again, thank you for being here. My name is Rosalind Calhoun. I'm the Reentry and Partnership Coordinator here at Bard Business. And on behalf of the Justice Reform Partnership, I just would like to welcome you today to our Talk Justice Tuesday post crossover day election review. Our coalition, just to give you our background, the Justice Reform Partnership, or the JRP, has grown from just 5 organizations to over 90 organizations and individuals working to advance meaningful criminal and juvenile justice reform across Georgia. Our coalition, we bring together grassroots organizations, community organizers, advocates, directly impacted individuals, and policy experts all come together to bring a more and just and equitable system for our state. So today, our Talk Justice Tuesday is a state legislative series that is focusing on discussing today some key issues and solutions relevant to communities that are affected by criminal legal systems. This series today is going to just involve some deep dives into specific policy questions and features insights from our community leaders, our advocates, as well as lawmakers about the reform opportunities at both the state capitol and within the communities. The Talk Justice Tuesday, the series is designed so that we can break down complex policy issues for the public. We can also amplify the voices of directly impacted communities, as well as identify actionable strategies for advocacy. So, as you know, crossover day has passed. So, thank you for joining us. We're going to just be breaking down some key bills that are still moving through the General Assembly. We'll be able to review what has advanced, what has stalled, and also what it means for our communities as we just head into the final stretch. So as we begin, we're going to start with Miss Ann. I want to just introduce Miss Ann Colleton. She is the Policy and Outreach Coordinator for Georgia Justice Project. Miss Ann will be facilitating this afternoon's post crossover day review. I also would like to let you all know we encourage you because there's going to be a lot of important updates for multiple panelists. So please, if you have any questions, go ahead and drop them in the Q&A box. And we also are going to have time to answer questions at the end of the session. So thank you again for being here, and I'll pass it to you, Miss Ann.
Thank you, Rosalind, for the introduction and kicking us off. My name is Ann Colleton. I work at Georgia Justice Project, and we are a proud member of the Justice Reform Partnership. So glad to participate in this. And I would like to just kind of talk about what does it mean to be post-crossover and just kind of give a brief review of the legislative process. So every 2 years, our legislative session is 2 years, and every 2 years, there's about 2,100 bills that get filed in the General Assembly. That is when a citizen or a lawmaker has an idea of a problem that they want to fix. They introduce it, and then it gets to be heard in a committee. And then a second committee called the Rules Committee schedules it for a floor vote. And so any bills that then pass that floor of either the House of Representatives or the Senate crosses over. So Friday was crossover day. And so any bills that made it through those first 4 orange boxes to that 5th box to cross over from, if it was a Senate bill, it had to cross over to the House. If it was a House bill, it had to cross over to the Senate. That's what we'll be talking about today for the most part. So about 975 bills each session cross over. So it's about 46% of the bills that are actually introduced get mass crossover. And then by the end of the session, once a bill crosses over, it has to go through that same process in the opposite chamber. So a committee hearing, the Rules Committee scheduling it for a floor vote and a floor vote. And then if there are any amendments that took place after it crossed over, then they have to have an agree vote from the original chamber. And then it can become law if the governor either signs it or doesn't do anything. It doesn't veto it. So by the end of the session, there's about 725 bills that become law. So about 1/3 of bills that get introduced become a law. So today we're going to be focusing on the things that did cross over. So I also would love for everyone to take a minute to pull out their phone, scan this QR code, and in a minute we can drop something in the link in the chat as well. But it's very important to know who your elected officials are. If you scan the QR code, you're going to get 2 elected officials. Once you put in your home address, you'll get 2 elected officials. One is in the House, that's your representative, and then a senator in the state Senate. So even if you are not able to vote, like if you are still on probation and parole, you cannot vote yet. However, you still pay taxes. You are still a constituent. You pay the salaries of the elected officials in the state. And so you can still have a voice and you can still make your voice heard to encourage them to pass or to not pass certain bills. So please look up who your own elected official is. Many times in today's, you will hear that we want you to call a certain committee rather than your own elected official. It can never hurt to call your own. So when it gets to the floor vote, we'll say call your own elected officials, but we might be focusing on a committee to start because that's when a lot of the amendments or things can get held up if it's a bad bill, or it can get held up if it's a good bill that we want to pass. So, but use this QR code and find out who your elected officials are. If you attended Justice Day, which I hope you did, we talked about these 4 bills, and we had advocates who went across the street to speak to lawmakers about these bills. So we will touch on all of these bills today. 3 of them actually crossed over and are continuing, and so we'll give a deeper dive and an action alert about what you can do to keep those bills either from passing or not passing. The first bill, 673, did not cross over, but because we focused on it at Justice Day, we wanted to give a brief update. So we will do that as well. And then, so today, these are the bills that we're going to be talking about today. And then I'll put a link in the chat so you'll have all these in writing, and so you don't have to screenshot if you don't want. But these are the good bills, the positive bills that we want to push for today. And then there are 3 bills that we would love to stop if possible. So again, I'll put that link in the chat. That's what we're going to be talking about today. And our panelists are going to walk through each of these bills. So the first panelist is Corey Clevenger. He is a citizen advocate who had something happen in his life. Then he said, this isn't right, and I want to make a change. And so dreamt up an idea of a bill, researched it, wrote it, and found lawmakers to introduce it. So he's going to share his experience with that bill that he is championing. And then we'll have Wade Askew, the policy consultant at Georgia Justice Project, Maisie Lynn Gurton, the executive director of the Georgia Association of Criminal Defense Lawyers, Brandon Bowman, who is the board chair of Restore Georgia, Darcy Garrett, the training coordinator at PAD, Atlanta Policing Alternatives and Diversion Initiatives, and then Blake Feldman, the senior policy counsel at the Southern Center for Human Rights. So please welcome Corey as our first panelist.
Hi, everybody. Here, just wanted to get everybody with our guest. After we set up committee hearing, around the time Justice Day, we were in the process of negotiating with Prosecutors Council. And during that time, we wrote a version of our bill that still includes everybody and addressed all the concerns that were raised at the committee here. The prosecutors were trying to exclude 12 out of the 14 possible crimes that kids can actually be tried as adults for. And through the negotiations, we actually got them to include 8 out of 14, or roughly half of the ones that they were trying to exclude. We actually could have gotten a second hearing the day before crossover day, but only if it was actually on the prosecutor's version of the bill, which obviously we don't accept. And so we just decided to hold out for what we know is right. So in the end, we ran out of time, but next year we're going to come back with a better plan, a better bill, and 9 months to get ready. So we're going to keep trying to work with DAs on the fact that, everybody should be included for this bill. No one should be excluded. Even from a legal standpoint, it's not logical. It just doesn't make sense. So we hope to actually get them on board at some point. And if not, we're going to keep talking to committee members and House reps, hopefully some senators, to try to make sure that next year when we go in, we've already got all the support we need to get it first. So I just wanted to thank everybody from yourself and my partner Mira, everyone who supported our efforts and believe in what we're trying to do. I think that this bill is a testament to the power of grassroots advocacy. Everybody matters. Every call you make, every conversation you have, every email that you send is an opportunity to change someone's mind. And that's what changes society. It's not even bills or votes at the end of the day. It's just changing people's minds on important issues. So basically where we're at right now, we're getting ready for next year and we can't wait to get started again. So hopefully y'all will be ready and send the word out when the time comes. That's pretty much all I got.
All right. Guess it's my turn to jump in. Thank you, Corey. So, hi everyone. I'm Wade Askew, representing Georgia Justice Project. And so, speaking today to the one bill that we also highlighted at Justice Day, that's HB 162. HB 162 actually got out of the Judiciary Committee last night, yesterday afternoon. So, I'll give a little refresher on what it is, what it does, and what the next steps look like. So HB 162, we are kind of framing as a First Offender Act modernization bill. Under current law, it is already required that if somebody successfully completes and is discharged from the First Offender Act sentence, that the records of that case are restricted. However, under Georgia law, we have a pretty unique way of limiting access to our records. Restriction only refers to an official GBI record. It doesn't refer to actual court records. Why that matters is that background check companies, they don't go to the GBI to find arrest and conviction or other types of records. They go to courts. For that reason, we also need not just this restriction order, but an actual sealing order. And a sealing order limits view of records that are held by courts and jails and every other kind of entity that would hold those records. So what HB 162 does is two things. One is very basic. It would require that courts restrict and seal records so that when people have a First Offender Act sentence and they're told this is limited from view to the public, it's actually effective, but that's actually happening. Second is instead of waiting until someone has completed a First Offender Act sentence, we're going to restrict and seal under this bill. We would restrict and seal First Offender Act records at the time of sentencing for two reasons. One is because once you ring a bell, once a record is public, it's hard to unring that bell, especially here in the modern digital age. And second, because just as a matter of basic workflow from the courts, we know that when people finish a First Offender Act sentence, people don't actually go back to court. People don't actually have a final hearing saying you're discharged now. It just is a date that comes and goes. And so as a matter of workflow from the courts, it actually makes more sense for them to do everything at sentencing. So we've been able to effectively make that case as this bill has gone through the process. So that is what the bill does, is it keeps a First Offender Act sentence records of that case private, keeps it concealed to the court, and other actors that under existing law would have access to those records, like law enforcement, the courts, probation will have access to the records, things of that nature. But for the broad public, we're limiting access to those records. We do it at sentencing and they stay under seal unless a person has their First Offender Act status revoked and they are actually convicted of the offense. And I should mention that in only 2% of cases is First Offender Act status actually revoked and a conviction imposed. So the grand majority of people we're going to keep under seal. So where we are now is we have passed the House. We actually did that last year. We are now in the Senate. We passed out of the Senate Judiciary Committee, like I said yesterday, the first possible hearing. So thank you to Chairman Brian Strickland for getting us scheduled as soon as possible after crossover day so that now we can focus on rules. So the bill sits in rules now. They can schedule it to go on the Senate floor to be voted on by the full Senate. So our focus is making sure that it's a priority. The name of the game with rules is to make sure that you are a priority for the Senate in its entirety to get this bill done. Once it is hopefully voted on by the Senate, the House will have to vote on it one last time because it is technically an amended version of the bill from what we originally introduced. The only updates are, instead of the bill going into effect in 2025, when we originally introduced it, it's now going into effect in 2026. So dates had to be updated. That counts as an amendment. So the House has to agree that we're going to update the dates. So right now, contacting your local, your representative to try to make sure that they are helping us be a squeaky wheel to the folks on the Rules Committee can be helpful in making sure that it is prioritized. And then also you can find people in the Rules Committee and try to reach out to them as well. But as Ann mentioned, representatives, senators tend to like to hear from their own constituents first. So that's where we're at. Those are the next steps, and we appreciate all the support.
There, I'm Maisie Lynn Garten, the Executive Director of the Georgia Association of Criminal Defense Lawyers. The first bill I'm going to bring to you guys today is House Bill 1061. So this is the current version of the Raise the Age Act, which now no longer addresses the substantive law around how children are prosecuted, but instead forms I forget what they're calling it. Let me just look. An organizational committee that will basically study the issue. The bill has been named for Mandy Ballinger. Representative Ballinger died during the interim after battling cancer for quite a long time. And this issue had been on her high priority list for a number of years. When she kind of inherited it from Mary Margaret Oliver, who has a long history as well of championing the idea of raising the age in Georgia. So at this point, the new chairman of the Judiciary Juvenile Committee, Beth Camp, has taken up this flag of raising the age. And this organizational committee is made up of all various stakeholders, everyone from members of the legislature, including, for instance, Chairwoman Camp, whoever the chairman of the Senate Judiciary is, organizations like the Prosecuting Attorneys Council, Georgia Association of Criminal Defense Lawyers, sheriffs, prosecutors. And it does set some timelines for when that committee will meet and when it will report out its findings. We are very supportive of this moving forward. And just so you all are aware, the sheriffs remain very opposed to the whole concept, and so opposed that they're even opposed to having a conversation about it in a committee format. So though they do have a seat at the table, we hope that they will take that seat and be in the conversation. I expect they will. But anything you can do to encourage your senators to vote on this, it now sits in the Senate Judiciary Committee, where we would expect it to be called for a hearing by Senator Strickland prior to signing day. Thanks for your support.
Good afternoon. My name is Brandon Bowman. I am the board chair at Restore Georgia. I'm going to talk about Senate Bill 468, which has passed the Senate and is now currently in the House. So let me start off with what Georgia already has. Georgia already has a risk-based classification system through the Sexual Offender Risk Review Board. This board evaluates individuals using validated assessment tools and assigns classification levels based on actual risk factors. What SB 468 does. 468 introduces several changes to the registry system, expands reporting requirements, adds new provisions for homeless registrants, and requires advanced notification for international travel, and requires certain housing programs to report when a registrant applies or is accepted. The most significant policy change, which is in Section 3 of the bill, however, is that the bill requires automatic risk classification for certain offenses rather than allowing the Risk Review Board to evaluate those cases individually. And this is why we oppose this bill. Georgia designed its current system around individualized risk assessments because not all cases present the same risk factors. Not each two cases of the same conviction have the same risk factors. Automatic offense-based classification reduces that precision. When classification becomes automatic, it weakens the role of the risk review board and shifts the system away from individualized evaluation. This bill also expands reporting requirements for administrative obligations that sheriff's offices must manage. Registry administration also already requires significant resources, so any expansion of reporting requirements raises questions about operational capacity. At Restore Georgia, protecting communities and preventing harm is obviously the priority. The question policymakers should consider is whether changes like automatic classification strengthen Georgia's existing system or unintentionally reduce the precision that risk-based assessment was designed to provide. The Senate bill had a substitute, but did not moderate some provisions, which extended the reporting window for homeless individuals from 12 hours to 36 hours and removing new monitoring authority for sheriffs. So that's all I have on SB 468. If you have any questions, please put them in the Q&A. I'll be happy to answer.
Thank you, Brandon. My name's Darcy Jarrett. I'm the training coordinator with PAD, and I'm going to be talking about House Bill 295. So the bill is essentially represents a shift from toward property rights-based enforcement and enforcement of what they call certain laws, and most of those have to do with what PAD is concerned with, and what I think the community is concerned with are quality of life offenses that are really impacted in mental health, impacted in experience of homelessness and the experience of poverty. And so what we see is that House Bill 295, what it actually does is it allows property owners to seek compensation from local and county governments for what they call or what they can prove or believe that the government has done, either in adopting a policy or pattern that does not enforce certain laws that are on the books. And the laws, as I mentioned before, all involve things that that we understand are a product of so many systematic and societal structures. So the laws specifically mentioned are public camping, loitering, panhandling, obstructing of a roadway or a street, shoplifting, drug possession, and public intoxication. And so our concern, and Moki Macias stated this during the session, is that this law, if broadly applied, could in itself make diversion programs a part of this, what someone might consider a policy or pattern of non-enforcement. Whereas we understand these are evidence-based practices, and diversion in itself is shown to not just perpetuate a cycle of criminalization, but in fact provide much needed services and access that we know is the core of the problem. And so we think that this we definitely see that this bill increases pressure on government to enforce what are quality of life offenses. We see this as a part of really a culture of increasing criminalization of homelessness and poverty, and creating more political and financial risk for government. There's some definite language in there that shifts even how liability is and the process, or in the and how one could account for business costs, property property values, which we know are not simply impacted in one way or another. So please put in the chat if you have more questions, and thank you for coming today and listening.
Hey everyone, Blake Feldman, Senior Policy Counsel at the Southern Center for Human Rights. And as Anne mentioned, a lot of really bad bills did not cross over, which is fantastic, but I am going to talk about one of them just because sometimes the substance of a bad bill could be revived or reappear in another. So I'm talking about Senate Bill 592, or the One Strike Act, particularly because of how terrible this bill is. So it's an 11-section bill. Sections 3 through 8 would really dramatically increase the sentencing ranges for ag assault, aggravated battery, kidnapping, and the rape or sexual battery of a child. Section 9 would add ag assault, sexual battery, aggravated battery, first-degree home invasion, and, quote, any felony involving the use or possession of a firearm during the commission of the offense, end quote, to the list of serious violent felonies. The current list, that would really drastically expand the scope of what are defined as serious violent felonies, which of course has lots of implications and negative collateral consequences. Section 10 would pretty much, it would revoke parole eligibility for anyone who is currently incarcerated, serving sentence for murder, assault, rape, distributing drugs, or a gang-related crime. And I'm going to talk about that in a minute. Parole eligibility would also be revoked for anyone who was in some way part of a drug trafficking organization. And Section 10 would also make anyone on probation for a serious violent felony ineligible for early termination of probation. So the entire bill is awful. I mean, for instance, ag assault right now, the sentencing range under current law is 1 to 20. This bill would change that to 3 years to life without parole. For aggravated battery, it would go from 1 to 20 to 3 to life without parole. For kidnapping, it would go from 10 to 20 to 20 to life without parole. So it's a really extreme bill. Particularly, we have heard lots of concerns with people about this Section 10 and the impact that it would have for people currently serving sentences who do have a possibility of parole, whether that would all of a sudden be taken away. We do think that that would be unconstitutional ex post facto laws. So essentially, when someone's sentenced, you can't constitutionally change what the punishment is or whether there is punishment for certain behavior after the fact. There's also other slightly more complicated constitutional arguments against the use of validated gang members or let me see what the quote is for anyone who, begin quote, was in some way part of, close quote, a drug trafficking organization. So particularly with these effects that this bill would have had to people who are currently serving sentences, the effect that it would have on their parole eligibility, there are serious constitutional concerns and arguments against that. Like I said, this bill did not cross over, but that does not mean that we shouldn't be and we will be watching other bills as they move through the process to make sure that this language isn't added to another bill. If it is, we'll be sure to update the JRP as soon as that happens. And if you have any questions, let me know, put it in the chat, and I'm going to pass it back to Mezuan.
Hi again. I joined Blake in bringing, word of a moving bill that we do not love. It is House Bill 1076. We talked about this one at Justice Day. If you happen to be there, it has not changed in its form since it was filed. It creates a new offense of obstruction of a law enforcement officer with a motor vehicle and would make that a felony offense if whether in a moving or a stationary vehicle, a person is accused of obstructing an officer. The punishment scheme for this code section, this new one, would be between 1 to 5 years of incarceration, coupled with a required fine that could be as high as $100,000. We oppose HB 1076. We do not want it to pass. The main reason is because it's redundant and we have laws in the books that already cover this behavior. And those include misdemeanor obstruction, which is a misdemeanor, carries up to 12 months in custody and up to a $1,000 fine. We also have felony obstruction. So when someone is accused of obstructing a law enforcement officer by offering or doing violence, which arguably, if a vehicle is involved, could be the case. And that punishment scheme is graduated. You'll see this in the one pager, but for a first offense, it's 1 to 5 years. For a second offense, it's 2 to 10. For a third offense, it's 3 to 15. And in all of those cases, there's a minimum $300 fine. There's no maximum stated in the code section. Best I can tell by some quick research this morning. Under Georgia law, our felony code maxes out fines that are unstated at $100,000, not unlike what's in this bill. Usually it goes unstated. And then there's a more egregious punishment scheme available for this kind of behavior under our aggravated assault statute, where we already protect law enforcement officers in a fashion by deciding that if they are the alleged victim of an aggravated assault with something other than the discharge of a firearm, they're special. I mean, they're special in that case too, but in this case, without the firearm discharge, they're still special. It has a minimum of 5 years, a maximum of 20 years, and it's a mandatory minimum unless there's a downward departure agreed upon. So it's no small thing to be accused of an aggravated assault against a police officer. And certainly if you are driving at someone with a vehicle, that would cause someone to be in reasonable fear of their safety. And that essentially establishes aggravated assault in Georgia. So our position is that it's a redundant and unnecessary law. And just for inside baseball for people here, it's not necessarily a talking point that's necessarily going to be captivating to lawmakers. But the reality is the more charges that a prosecutor can list on an indictment, the more likely someone is to take a plea to something lesser, because the accumulation of all the possible punishments on that indictment, unless there's some ability for the charges to merge or the sentences to merge, it makes it really difficult for someone to want to try to face all of that burden at trial. So the fewer redundancies we can have, the less likelihood we have for people to be stacked and stacked and stacked on indictments. Again, not an argument for legislators, but just to help you understand why redundancy is a problem for us when we look at these criminal codes that the legislators want to enact. I hope that's helpful. Please let us know if you have any questions. I think we're all going to hop on now.
Yes, thank you. Thank you so much to all of our panelists. We know this legislation session has been incredibly tough, and today we have shared a lot of information about policy, advocacy, and just the real strategies it takes to move this work. So we want to take a moment, and we just encourage you all to drop your questions in the Q&A, and we are going to answer all of them because we want to make sure that you are very clear. And if something sparked a thought, or if you're wondering how you can continue to stay connected for your community and through your advocacy work, we want to make sure that we take this time to take your questions.
Yep, and join us at the next Talk to Justice Tuesday, which I think is April 14th, the second Tuesday of the month, where we'll talk about after the session what ended up actually passing. So it'll be kind of a next step after this as well.
Maybe I'll take up a little space since we have a little air time here, just to say, as the training coordinator with PAD, we have a training that is it's a big undertaking, but I think it's worth it to talk about compassionate response. And it's called Expanded Networks of Care. And if you find yourself wanting to be with someone who is experiencing some quality of life concern, this is a way to talk that through with people who have been doing this work for a while. I come to this work with not just lived experience of homelessness here in Atlanta, but also of walking with people for about the last 10 years. And I'm a certified peer specialist. And so, yeah, just a place to kind of bring some of that energy of what can I do and how can I make an impact. And I'll go ahead and drop a link that folks could register. Actually, I'll just probably put our website on there because that's a way to find all of our trainings. Thank you.
Thank you so much for that. Does any of our other panelists want to chime in or have something that they would like to share?
Yeah, I just posted in the chat. SB 468 was just scheduled for this House Judiciary Non-Civil Committee meeting for tomorrow at 1 p.m. This is a bill that I deeply and personally oppose, but like and I hope I would get support for others to oppose, and not just on fundamental reasons, but procedural, and it's kind of overreaching in terms of like getting people back into society. So, for any questions, please feel free to like email me. And I saw a question was at 1 p.m. or 9:30. I see it for 1 p.m. tomorrow.
Thank you, Brandon. The other thing I'll just add is that if people have questions about the legislative process, I'm happy to answer those sort of procedural questions if people are like, what's happening with the bill? Where does it go next? And things like that, because I know it can be a very confusing process. So I like helping people understand how that works. So I put my email in the chat. So feel free to reach out to me if you have general questions about that.
I just double checked, and that hearing's at 9:30 tomorrow morning, not 1 p.m. My apologies.
Thanks.
I will share that on March 16th, the protected class will be in Augusta. We have a protected class ordinance that was passed here in Fulton County, and we are moving it into Augusta. And this is the first time that we will have the opportunity to present it to the commissioners. So if anyone would love to join us in Augusta, we are traveling down. We're taking our van, or you can meet us there. I have put my email address in the link. I welcome you to please contact me. This is a very big moment for us. We've been working on this for over a year and a half. So we need as many people to be able to fill that room. We have folks who are even flying in who are just impacted to speak about moving this ordinance. So we definitely appreciate all the support.
All right. Well, I just want to say Nikki's coming on. Okay. I wanted to say thank you to all the panelists for sharing today amidst the busy capital season. And Nikki, you want to close us out?
Yeah, sure. Thank you. I saw you put in the chat about our final legislative talk Justice Tuesday. It'll happen after the session ends. But first, I want to thank all the panelists who came on. You see that some are still at the Capitol, still working. But our final talk Justice Tuesday will be April 14th. It'll be our normal 6 o'clock time. We had a noon schedule today because a lot of our panelists are still in the midst of things, and we thank them. But our 6 o'clock Talk Justice Tuesday on April 14th will be after session ends. It is a link in the chat. Registration is open, and we'll put that on the website. It'll be there maybe at the end of the day. But do you have the slides? And I did link it on the final slide. So if they're shared in there, folks can go ahead and register for that April 14th. But by then, we'll know how some of these bad bills have happened, and hopefully some of the ones we talked about today would have died. And, we will have some great things to talk about. And some of the great ones, the good ones, well, have passed. But Talk Justice Tuesday does not end on the 14th. Our Talk Justice Tuesday is a monthly series that we host. So we'll continue always the second Tuesday of the month. So just check our website for continued updates with our partners. So we just thank you all for joining us in the middle of the day on a Tuesday to talk about some tough issues. So if you haven't had your lunch, get you some lunch, but we really appreciate you. We always share our videos out on YouTube as well, and they'll be linked on our website for the folks who registered and weren't able to join us. So but that's all I had, but we thank you.